Recording now. Okay, so I'm very happy to see everyone on our English Speaking Club November session. My name is Danaya. And today I would like to introduce our honorable speaker, Mr. Roy Pearce. He is a member of the AIFC Legal Advisory Council and a partner at Baker McKenzie LLP. And I won't take much time from our speaker to introduce himself and tell us what we are going to discuss today. Mr. Pearce, the floor is yours.
Thank you very much, and I'm delighted to be speaking again at one of these really good events. I'm a partner at Baker McKenzie, as I said. I actually began my career in Kazakhstan with Baker McKenzie during the first phase of privatizations. And I've worked in the former Soviet Union for many years, including Russia and Ukraine, as well as Kazakhstan. And then I've been based in London for the past few years, but I'm a regular visitor to your part of the world. And my area of practice is capital markets. So I advise clients on IPOs and also on Eurobonds. And that's what we're going to talk about today. And just to say, if I'm talking too quickly or too slowly, just let me know. And I'm also happy if anyone wants to ask a question while I'm talking, just feel free to interrupt, but we will have time to discuss at the end. So let's kick off. And we're going to be talking about IPOs and preparing companies for IPOs and what lawyers actually do in an IPO. And why talk about IPOs at all today? Well, obviously, they are in the news in Kazakhstan. I'm sure you've all been looking at what's going on in the oil and gas sector, which is tremendously exciting. And more broadly, of course, the government in Kazakhstan has plans to prepare companies for IPO and listings on stock exchanges, whether domestically or abroad. And that is a natural phase of most economies as they develop and the governments look to attract foreign investment and improve the efficiency and profitability of their major state enterprises. And so selling shares to domestic and international investors by way of an IPO is one of the main tools available to governments. And we've seen a number of companies, obviously, from Kazakhstan and from the neighbours successfully and sometimes less successfully list their companies either on the home market or on a foreign exchange. But let's actually just spend a couple of minutes to look at what an IPO actually is. So put very simply, it's an initial public offering of shares, or it can be other securities that represent those shares, to a widespread group of investors. And these investors might include the public at large. So, for example, in the first wave of privatizations in the United Kingdom in the 1980s, when Mrs. Thatcher decided to make public companies available for public investment, and we had successful offerings such as British Gas, they were largely targeted at retail customers, ordinary individuals. But there were also many IPOs which are just limited to sophisticated professional or institutional investors. And sometimes there's a mix. So there'll be retail investors and also the big funds. And in an IPO, the company might be issuing new shares in order to raise capital to fund its growth. And that we refer to as a primary offering. Or alternatively, the owners in a private sector company might be looking to sell all or part of their shares to monetize their investment in the business that they've grown, or to exit the business altogether. In the state context where we're privatizing companies by way of an IPO, then the aim is to generate revenue for the state budget. And we call these secondary offerings. So when you have the selling shareholder, either private shareholder or government selling, that's a secondary offering. And it's very common to see a combination of the two, company issuing shares to raise capital and shareholder or shareholders selling part of their stake or all of their stake. Now, typically, the offering of shares is combined with a listing on a stock exchange or even several stock exchanges. And this obviously means the shares can be traded very easily. it means the company will be able to access capital in the future by a follow-on offering of the shares on the same exchange. And if you have listed shares as a company, you can use those listed shares as an alternative to cash when you're acquiring other businesses. So I think we can move to the next slide. Yeah, so we've talked about, I think, the first group of bullet points here, which is really why go public, and maybe the reasons I've mentioned are the obvious ones. Listing a company's shares, though, also means that the company is going to be much more transparent, because firstly, the IPO and the listing involves the preparation of a prospectus, which has a very detailed set of information about the company and also about the risks inherent in the business, so that investors can make an informed decision, are these shares the right investment for me? Being listed also really improves the company's visibility in the market, and that can also help it to attract other funding. So once you've listed shares, it's easier to issue bonds, by way of example. And there's also a continuing requirement to publish information about the company. So anything material that happens to the company, good or bad, must be disclosed to the market. And there's a continuing requirement to publish annual and periodic financial statements. So the company is well known to actual and potential investors, and that really improves its ability to secure funding. Now, listings usually also require that the company meets certain basic standards in terms of corporate governance and internal reporting procedures, including having a properly accountable board of directors and management team with committees responsible for overseeing key areas of the business, such as audit, remuneration, risk. So it really does improve the efficiency of the business if it's done properly. And that's another reason why listing a company is an attractive option for a government to improve the efficiency of its main state enterprises. So let's talk now about who is involved in an IPO, obviously apart from the company and the shareholders. Well, usually the company will hire one or more investment banks, and their job is to manage the process. So they will prepare a detailed timetable setting out how the process is going to run, who does what at what stage, and what are the various work streams that are involved. They advise the company on the most suitable exchange for the listing. They carry out diligence to check the company is actually suitable for listing, and they coordinate the work of all the other advisors. Then they prepare marketing materials. They take the company on a roadshow, usually domestically and internationally, to meet potential investors. And then finally, based on the feedback they get from those investors, they help the company to price the shares and then place those shares into the market. And those banks have their own counsel, and they draft the underwriting agreement, which is the arrangement by which the banks agree that they will initially purchase the shares and then place them with the investors that they found in reliance on certain assurances from the company, such as, for example, we've provided all information necessary for investors in the form of prospectus, and we guarantee that prospectus is accurate and you can rely on it. The company's lawyers will, let me mention the accountants next. So the company's accountants are very critical in the process. They audit the financial statements that investors will rely on when they're looking at the potential investment, and they check all the financial data that is in the prospectus. The lawyers, company's lawyers that is, they guide the company through the listing process. They liaise with the stock exchange. They draft the prospectus. We'll talk more about that. They carry out diligence to ensure that prospectus is accurate. So you've got another set of eyes on it. You're not just relying on the company saying it's accurate. You've got lawyers checking. And they negotiate the underwriting agreement with the banks and their counsel on behalf of the company. So that's what the lawyers do. We'll talk in more detail in a minute. Normally, you also have PR consultants and IR, international sort of investor relations people who will be involved usually from the start of the process. And they help the company get ready for life as a public company, because as soon as they go public, as I've said, that company is going to be subject to continuing obligations to publish information, to communicate with the press and with investors, and generally to manage its public profile. Now, I'll talk a bit more about what company counsel does. So I think we can probably go to the next slide now, please, Logan. Yep, thank you. So one of the key jobs that we have to do as companies lawyers is to actually draft that prospectus that I've talked about. This document is used to market the company shares to the investors. So it's a selling document. It describes the company's business and its competitive strengths and its strategy, how it's going to achieve its growth plans. It describes all of its key products and its customers and its management team. And it's all very positive, and it says how great the company is and how great its products and how great its strategy is and how great the management team are. And that's all wonderful. And then there's also a section on all the risks, everything that can possibly go wrong with investment. And this is the part of the document that the company's management really, really hates, because we take 50 pages to explain how great they are, and then we take 50 pages to say, but on the other hand, here are a number of problems, here are various things that can go wrong. Now, to do this, as lawyers, we have to understand the business, and we have to describe the business in a way that investors who don't necessarily know the market will understand. So this often involves explaining the realities of businesses in the former Soviet Union to foreign investors who may have very limited or no experience in the region. So, for example, I've advised a number of mining companies from the former Soviet Union on listings overseas. And from personal experience, I can tell you that there are often a number of irregularities in the way that they obtain their mining licenses, title to land. There may have been defects in the anti-monopoly approvals that they've obtained over time. And they may also have business rivals. And those business rivals may use aggressive methods to try and even block the IPO from happening. So, for example, I had an experience where I was advising a company from Ukraine, and a former business partner, now business rival, alleged that our clients didn't actually own the business, and they launched proceedings in the High Court. They wrote to the Financial Times, they wrote to the UK regulator, they wrote to the London Stock Exchange to say, look, this company you're about to list doesn't really own its assets. And so we had to sort that litigation out as part of the process. So really, I think our job, if we're lawyers operating in Kazakhstan or neighboring countries, a large part of our job is to explain to foreign investors and foreign regulators and investment banks the realities of how business is conducted in this part of the world. So all of this obviously means that we need to spend a lot of time understanding our clients' businesses. And as lawyers involved in an IPO, we actually need to visit the client's facilities. We need to talk to the management. We need to talk to the staff. And so in my career as a lawyer, I've flown around the whole of Kazakhstan to physically check that Kaztrans gas pipelines actually do exist. I've been down coal mines. I've been down the Shakti Milenina. I've been to open cast mines in Ekibastuz. I've been to copper processing facilities in Balkhash, mines and steel plants all across Ukraine. I've been to hospitals in the mountains of Georgia. I've been to visit an oil facility in Angola, a dairy company in the desert in Saudi Arabia, to inspect cows living in air-conditioned sheds in the middle of the desert. And the most fun, as I was saying to my colleagues before we started this presentation, I went to a snack food factory in Egypt, just outside the pyramids actually, and watched chocolate biscuits being manufactured, which was quite fun. As I've mentioned, I mean, sometimes as we're doing this process, we discover problems that really could either prevent the listing from taking place at all, or would have a negative impact on the price, because any defects that you uncover when you're doing your diligence are either going to have to be fixed so the problem goes away, or you're going to have to disclose the problem. Now, another part of our job is to look at the assets that are inside the listed business. And sometimes we might say, well, there's an asset that we don't really need, it's surplus to requirements. When we were privatizing the coal mines in Kazakhstan many, many years ago, lots of them had non-core businesses. They had clinics, they had kindergartens, they had factories making socks that we simply didn't need as part of the business. So sometimes you could find yourself advising on a restructuring as part of the IPO process. And so that is a large part of our day-to-day job when we're getting a company ready for the IPO. Another part, which is equally important, is to make sure that the directors and the management team are ready to manage a public company, which is very different from managing a private company. As I mentioned, there will be continuing obligations to make sure that any material information is disclosed to the market and to investors immediately. And directors' duties as directors of a listed company are different. They are subject to a different level of potential liability. And so we provide a lot of training so they're familiar with those duties and those responsibilities. So I'm going to take a pause there because I'm conscious I've been talking now for some time and just see if we have any questions at this point.
Everyone is welcome to turn on their microphones or list their questions to the chat box. I'm happy to read them out. Don't be shy, we are all friends here.
Can I ask if anyone's been involved in an IPO?
Hello, everyone. Well, I'll start if I may. Yeah, Mr. Pearce, I wouldn't be right if I don't ask the question on the recent IPO by Kazmunagas, and what's your thoughts on this, and wasn't it a bit too rushy?
Yeah, it's a very good point. I won't comment because I wasn't involved in the IPO process. I will say I have had some involvement in the planning stages quite early on, and I've had similar discussions with or about other proposed IPOs in Kazakhstan. And so there's a number of different factors, and one of the factors is political, because usually governments are keen to demonstrate that they're able to get an IPO done. And sometimes there's a tension between the government's expectations for when they're going to do an IPO and management and the advisors saying, we're not sure that we're ready. So to give you an example from Africa, I was brought in to talk to the management plus a number of people in government specifically about this point, because the management team knew very well that they were not ready for IPO, and the government really wanted to get the IPO done before the next elections. And so my job was to really talk them through, well, if you're going to do this, this is what you need to have ready. And all the issues I sort of mentioned, I said, well, if we uncover any sort of problems during the IPO process, if they're significant problems, we potentially have to stop the IPO, fix the problem, and then start it again. So there's always questions about whether it was the right time. But then sometimes if you delay, you miss a marketing window. So, you know, I can't comment on the precise circumstances of this particular IPO, but yeah, there are tensions certainly.
Thank you. Thank you.
The other thing I was talking to my colleagues before is the price, because I have never worked on an IPO, I think, where everyone has been 100% happy with the price. And that's an interesting part of the exercise. And it's not really the legal part, but it is interesting. So I mentioned that, you know, one of the jobs of the banks is to prepare the investor meetings and then take the company on a roadshow. And when they're doing that, they're getting feedback. They'll have their own views, but they're getting feedback from investors on what everyone thinks is the right price. And they get indicative bids where investors will say, well, I'm prepared to pay 7,000 tenge, I'm prepared to pay 10,000 tenge, per share. And what the banks have to do is they have to build up an order book, and they have to ensure that there's a good mix of investors. So people who are going to hold those shares long term and be supportive investors. And they want a certain amount of investors who are going to buy and then sell on, and that creates liquidity in the aftermarket. So a successful IPO will be the price that meets the objectives of the selling shareholder, because the selling shareholder will think, okay, well, in my view, the business is worth X, and that's what I expect to receive. The bankers will have an interesting exercise, because they want to make sure reputationally they do a good job. And so ideally, they want it to be priced at a level where the client is happy, but the price then goes up after IPO because people are trading and there's a lot of demand, but it doesn't go up too far. So I had an experience where the price jumped about 40% post-IPO. And of course, the shareholders were then saying to the banks, well, obviously, you really got the price wrong, and we lost a huge amount of money on that process. So it's a tricky exercise to get right.
Well, talking about the price, I'm not really sure if it's right or wrong, because I'm not an expert and I can't say anything on the price if it's high or whatever. But it's really makes me wonder, and makes me very surprised how, if I'm not mistaken, the market cap of Kazmunaygaz is less than the fintech company from Kazakhstan, Kaspiev. I'm sure you've heard of this case.
Yeah.
They've been listed in the London Stock Exchange, and it's really surprising. I mean, you look at the Kazmunaygaz, they've got all these facilities, plants, lots of oil. They've got shares in all these three biggest supergiant oil fields.
Mm-hmm.
And you look at the Kaspi, which is basically one office with lots of just finished university graduates and
Yeah.
bringing more value than the whole Kazmunaygaz. That's really impressive and tells a lot of the times that we're living in.
Exactly. And I think probably the environment that we're in now, 3-4 years ago, none of us would have predicted. So there's a number of things that drive it. Clearly market risk and geopolitical risk are major factors. So I've seen IPOs that are pulled because of geopolitical tension, and people are saying, well, look, it's a great company, it's a great asset, but it's not the right time to do the IPO. I mean, I had a great client in the pharma sector in Ukraine, just about ready to IPO in 2014 when Maidan happened. And so, if they had gone ahead and done the IPO, the price would have been significantly lower than it should have been, simply because of geopolitical tensions. And that's one of the main factors that affect sort of emerging market IPOs. There was a very long period, as you know, when there were very successful IPOs, and a number of Russian mining companies came to the London Stock Exchange. And there was a dynamic behind it where everyone was rushing to get into the same sector. So investors were driving the price up in many cases far beyond what I think people thought was realistic. So it can work both ways.
And just one more question. Sorry.
Sure.
Just you touched upon the mining sector, and just remember the case of the Kaz Minerals. I'm not sure if you're aware of this. It's one of the, probably the biggest mining company in Kazakhstan, and they've been listed on the London Exchange for some time, but then with the acquisition of the Russian asset, for some reasons I don't know, they've been delisted. So what's your thoughts on this, and why do you think a company like that would just all of a sudden decide to be delisted from the market?
Yeah, we have seen a number of delistings, and we've been involved historically with Russian businesses that have delisted. In some cases, there is a concern on the part of management that the regulator is going to delist them anyway, so they preempt it. In some cases, I think people take a view that because we're in this continuous disclosure regime, and bad things are going to happen, the share price is just going to go down and down and down, and we're going to have to keep putting out negative information into the market. So why bother? Why not just take ourselves off the list? And so we've certainly seen that, and particularly any company that has exposure to sanctioned businesses. So if your business model means that you're highly exposed to, let's say, Russian entities that are sanctioned or under sectoral sanctions, then again, you might find that you've got institutional shareholders that will be pulling out because their rules will simply say you can't have an exposure or a security in a business that has a significant exposure to sanctioned counterparties because of the risk of contamination. So at that point, some companies think, let's just go dark, if you like, delist, and maybe they'll relist again in the future. Or they might find that the listing simply is no longer generating the benefits that they expected, because there's a big compliance cost, just in maintaining your ability to comply with the regulations. That's also a factor.
Thank you, sir.
So pleasure. I can't comment on the precise circumstances of that company, but those are some of the reasons why you might.
Yeah. I got it.
Yeah.
Thank you.
Excuse me, Mr. Pearce.
Hello.
Hello. I would like to continue discussion of IPO of Kazmunaygas.
Sure.
Therefore, according to your thoughts, you do not recommend us for individual investors to invest in Kazmunaygas shares because I have analyzed the financial statement, profitability. For example, currently the share of Kazmunaygas, which will trade it on IPO, is 8,400 tenge, and minimal dividend per share is about 400 tenge. It's about per year 5% profitability. But now due to high inflation, the base rate of National Bank increased, and in Kazakhstan local bank deposit in tenge profitability goes till 17%. Therefore, 5% and 17%. It seems that it's more for individual investors to invest in deposit to Kazakh banks than in IPO of Kazmunaygas.
As a lawyer, I will give you a very lawyerly answer, which is that I would never dare to advise anyone on an investment. So I wouldn't say whether or not I would advise you to buy or not to buy. It really depends on the individual circumstances. And that's why you'll see, usually in an IPO, there's a lot of disclaimers. You need to read this material carefully, you need to analyze it thoroughly. If you don't understand anything, talk to your broker before you make a decision. Now, people invest obviously in equity for different reasons. In some cases, it's because you think there will be a longer term upside. So you might think, okay, I'm not talking specifically about Kazmunaygas or even the oil and gas sector, but you may make a judgment. You might think, look, this particular company, I've read the financials. I have studied the market where it operates, and I've studied the product. And in my view, this is going to grow long term, and it might be cyclical. So it might be the case that in today's environment, the market price for whatever that company produces is low, but I can see that over the past few years or decades, the price of that commodity or product has gone up and down, and it will go up again. And I'm satisfied that this is a well-run company. I have no significant concerns that they're going to lose their license, or the government is going to shut them down, or they're going to face a multi-billion-dollar lawsuit based on what they've told me in the prospectus. My personal judgment is that this price will go up over time, and I'm not expecting a return in 6 months or 12 months. I want a security that will grow steadily over years and years, and I'm going to put that into my long-term savings. And that's a rational way to look at it. You might think, you know, this is a startup, let's say in a tech business or healthcare. This is a really good product. I'm not going to mention blood testing or anything like that, but this is a really good product that no one else has thought of. It's relatively untested, but again, I've looked at the IPO and they've explained, well, it is risky, it is a bit untested, but we think it works. We've identified a growth strategy for our product, and we think it could take off. It is risky, it's not for everyone. But you might think, okay, I've got a bit of cash. This is quite speculative, but if this succeeds, it's going to make a lot of money. So that is another way to look at it. Another way to look at it is, look, this is a business that's been growing and growing and growing. I think it is going to achieve my growth expectations in the next 5 years. And that's a suitable investment for me. But the thing with an equity investment is, you know, your risk analysis is, I'm buying this share. I have to be reasonably comfortable that if I need to sell this share, there'll be a market for it. I have to be reasonably comfortable with what the directors have told me about the expectations for dividends, if I expect dividend income from it. So you've got to do a lot of homework, which is read the prospectus and make your own judgment call. And you know, it's certainly the case that you might look at something and conclude, well, look, they've done the IPO for whatever reason. I think it is cheap, right? I think it's good value, and I think it will grow over time. Maybe not in 6 months, but it will grow over time. That's just an assessment that every individual has to make. Now, it's a different approach from the bond market, because if you're buying bonds, you're a very different sort of investor. With a bond, what you expect is stability. You are being told, okay, this is a bond that is going to pay a certain coupon every 6 months or every year for a fixed number of years. And you don't really care whether the business grows or not, because you're not exposed to any equity upside. You're concerned about the fact that this company will continue to operate in a stable, predictable manner and generate cash to service the bond. And that is all you care about. So you have a very different set of expectations. So briefly, you know, investing in the equity market is a different, very different sort of thing from investing in the bond market. And there's a discussion going on right now in the UK, because UK investors traditionally have been quite happy to invest in equities. And there's a lot of small companies, small cap companies on the AIM market in the UK. And these are often growth startups. They might be mining companies that have yet to produce anything. All they've got is a title to allow them to start prospecting, but no revenue stream. They may be IT startups. And so you get investors quite willing to invest in companies like that, as well as the big multinational oil and gas companies or the big banks, where people are just expecting a stable dividend stream. But in the UK, we don't really have a retail market for bonds, so investors don't really have that opportunity. So a debate that's going on here in the UK is actually opening up the bond market for retail investors. So, which is a very, very long-winded answer to your question, but hopefully that was interesting.
Okay, thank you for your thoughts and judgments. We'll analyze ourselves whether to buy or not.
I think every lawyer knows that it is very dangerous to talk in front of other lawyers. So you even become a financial analyst like Mr. Pearce did today. If we just leave this topic with the IPO of Kazmunaygas, Mr. Pearce and I, before we started this session, we were talking about a lawyer counseling the companies on IPO, starting to be an expert in this industry. Could you tell us more about that, please?
Yeah, that's one of the more interesting parts of the job, actually, because as I said, we have to spend a lot of time getting familiar with how the business operates, and so you learn some interesting things. So one of the more interesting exercises I did was for a chemical fertilizer plant, and when I started, I knew nothing much about chemical fertilizers, but it's critical, that we as lawyers advising the company do understand the business thoroughly, because one of the jobs, as I mentioned, is to prepare the prospectus, and for all the reasons we've just been discussing, you have to have a very clear analysis of how the business operates and what are the risks associated with the business, so that investors can make that judgment call. And if you take something like the chemical fertilizer business, firstly, it's quite a complex process how these products are produced. There's broadly 3 or so different types of chemical fertilizer, but essentially they're all made in a similar way, which is based on natural gas, and then they're treated. And what you need to understand when you're looking at the risk profile of the business is the fact that, number one, it's very dependent on the price of gas, because the price of gas affects their production costs, and therefore affects what they can charge for the product in the market. It's also heavily dependent on agriculture, because obviously you're selling to agricultural producers, and agriculture is itself a cyclical and a seasonal business. So demand will go up and down depending on when the farmers need the chemical fertilizer. So you have to understand, are you selling to farmers in the north or in the south? When are they buying the product? And how does that interplay, demand, how does that interplay with the price of natural gas, which is your core cost? And then you've got to think about global transportation. And that is deeply affected by, or has been deeply affected by, shipping to China. So all these different factors will affect the financial results and future profits of a chemical fertilizer business. And one of the sections we haven't talked about, but in a prospectus, you will normally have a section that talks about all the factors that can affect the business's operating results and profits. And you have to analyze how those have changed over the past 2 or 3 years. So you really have to study the economics of the business. Then you've got to read the accounts, and then you've got to sit with the CFO and the finance team and say, just take me through every one of the line items. Why did your income go up? Or why did your costs go down in that year and the opposite in the following year? And you have to explain all of that to investors, as well as who are the markets that we're selling in, who are the customers. You have to explain the nature of the business. You have to explain the chemistry of the product. You have to explain the risks. You're using ammonia, which can be used in explosives. So you have to have security at your production facilities to stop people from stealing it. There's a huge risk of fire and explosions at these facilities. So you really need to sort of understand not only the business, but the overall industry itself. And that's, I think, one of the most interesting parts of the job.
Thank you. Okay, maybe someone else wants to ask a question. I think I've heard someone. No?
May I?
Yeah, sure.
Hi, Roy. It's a great pleasure to see you today with us.
Right, very nice to see you as well.
Yeah, and actually, it's We're very grateful for you to have you today, because bear in mind that you as actually one of the most senior legal counsels at one of the biggest law firms in the world, and for us to together for this topic today, this speaking club. Thank you for that. I have just a question in regards, maybe not a legal one, but just in general. In recent years in Kazakhstan and in neighboring countries as well, personal individual investment, like via brokers or via Kazakhstani brokers, or maybe foreign as well, has been gaining more and more popularity. And of course, you have touched this question in your last answer. Being engaged in legal expertise of companies coming for IPO. So you know how this industry works actually from the inside. And if you had time, would you be interested, or what would you prefer to maybe to deal with that individual investment, maybe by yourself, or just to deal via a broker, or does it have a contract and put some stake of money for that? Are you personally interested? Of course, we know that we as heavily engaged lawyers do not have any sufficient time to follow all the news on a daily basis. But are you interested in that, or?
Yes, it is interesting. I think because you can't help but be involved in that aspect of it, because as capital markets lawyers, you know, our job is not to sit in an office and say to someone, the securities law says this, although we do get asked those questions. But our job is very much to make an IPO happen. And so I've talked a lot about the challenges that sometimes happen when you're trying to list a company, and some of them are legal, some of them are not legal. I've mentioned sort of strategic litigation, all the things that can happen, you know, things that we have to do to get a company IPO ready. So when you are involved in that process, you're often also involved in talking to brokers and understanding how the brokers approach things and how they operate. And then when the company's listed, one of the most common questions that we are asked, and in fact, I was asked this question at 11 o'clock last night, and again, I was on a call at 7 o'clock London time this morning to discuss it. We had a client that had a counterparty that has just been sanctioned. And so that raises all kinds of issues. Is that going to affect the share price, and how? What does the client need to say to the market, if anything? And so sometimes there's a question, you know, something has happened, do we need to make an immediate announcement to the market? And if so, what will it do to our share price? So we spend quite a bit of time talking with the brokers to understand, because often when a client says to us, do we need to disclose something to the market? We are immediately thinking, is it inside information? And inside information is information that is not public. It's not known to the market. It's only known to a few individuals. It's known to the company. Is it material? Does it relate to the company or the company's shares? And if it were known to the market, would it affect the price of the securities in a material way? And there is no test of whether the share price goes up or down 10%. It's quite an art, not a science, to determine whether something is inside information. And so often we will speak to the brokers and say, well, look, from our perspective as lawyers, we've just been told something. We think it potentially is inside information, but how would an investor see it? And so the broker will say, well, actually, it wouldn't bother me at all if I had my money invested in this company, and this is why. Or I might say, look, I've just been told about this. I don't think it's material at all. And the broker might say, well, actually, the market really, really cares about this piece of information. And this is why. And so you pick up, you know, some knowledge of how professional investors approach things. And it is sort of tempting to think, well, actually, it would be interesting to be investing on my own account. The problem is, as lawyers in private practice, we have so much inside information in a professional capacity because clients need to consult us, and we can't do anything with that information, that we are in most cases very, very heavily restricted. In a large firm like mine, I don't know if I invest in something whether one of my colleagues on the other side of the world is involved in a situation where he or she has inside information. And so someone might think, I've got inside information, and if I trade, that could then be potentially an offense. So we generally, don't trade until we retire. Yes, it is an interesting one, because it's quite tempting to think, well, actually, if you spend a lot of time dealing with this business, you're in a pretty good position yourself to study the market, look at the prospectus, and make your own decision. But yeah, a lot of people will say, I'll simply rely on my broker. And there are some very good brokers out there. There are also some less good brokers out there. So I've certainly been in situations where a less reputable broker has sold clients products that are not suitable. So, for example, in the UK, I've encountered corporate bonds with very little disclosure that should not really be sold to retail clients, that brokers have sold to retail clients and have said, look, this is a great client. It's in the property sector. It's letting flats to students. It's a growth area, and they're offering a bond with a 10% coupon. And to me, a UK company offering a 10% coupon, then warning bells start to go off. So yeah, I'm happy to rely on brokers that I know and trust as professional brokers, but it's like making your own investment. If you're relying on a broker, you need to do your homework on the broker as well.
Thank you. And one more question, just from your personal experience, how many projects can you as a counsel or as a team lead or be engaged like simultaneously? I mean,
yeah, that's a good question from a practice perspective. I think it depends on probably where you are in terms of seniority, because you might be a senior partner and you might have oversight over a number of projects, but you would typically have a senior associate who would be the lead person on a major project like an IPO. And if you are that senior associate on that IPO, that will be your life for several months. When I was a senior associate, I did a couple of IPOs that were quite complex because they were for companies from emerging markets, and all the things that I've mentioned that can go wrong, did go wrong for this particular client. We had a lot of work to do our diligence and to check that they really did own the assets. There were defects with the title to land, with some of the licenses, with some of the anti-monopoly approvals. We had to fix all of those. We had a tax restructure. We had to restructure the entire group before we IPO'd. We had business rivals that threatened us with litigation and started litigation, so we had to engage with that. And this process went on for months and months. So if you are the main lawyer, you can do a couple of other things on the side, but that really is your life, and that is your life 7 days a week until the project is finished.
Thank you, Rod.
But it is, I can tell you, it's very personally satisfying when you do actually complete a major IPO. It's very rewarding. It's nice when you actually see your company appear. One of the most interesting things is when you do list. So in the London Stock Exchange, when you do list, there's a party basically 8 o'clock in the morning when the trading goes live. The first day when your client becomes a public company, if it's a prominent IPO, you go to the stock exchange and you stand on the balcony, and they have the stock ticker and you see your client's sort of stock ticker for the first time, and everyone drinks champagne, and it's a nice experience actually.
Yeah, press and button. Yeah.
I've just seen yes, exactly. I've just seen a question that's come up on the chat. Is there any special certification or qualification for legal experts to do counselling in an IPO? Can in-house lawyers switch their careers to capital markets lawyers? I'm afraid I've been very persuasive in talking about the fun that you have as a capital markets lawyer. Yeah, there aren't really any special certification or qualification requirements, no. So any lawyer really can advise on an IPO. It is reasonably specialist in the sense that you need to be familiar with securities laws and the listing rules in the jurisdiction where you're going to list. So, for example, if you were doing a dual listing on the AIX and the London Stock Exchange, you'd need to be reasonably familiar with both rules, whether you're a Kazakhstan lawyer or an English lawyer, because your offer document will need to comply with the rules of both exchanges and both regulators. And so there will be detailed disclosure rules where the exchange will say your prospectus must meet the following standards and must contain the following information, because then you have to prepare your disclosure document to that standard. So you need to understand how those rules work. But there's also principles. So the rules for most exchanges in developed markets are quite similar in terms of what has to go into the prospectus. But a lot of it is based on market practice, and a lot of it is based on common sense. So I usually say to someone that the test is, if I were investing in this company, what information would I need to know? And it's almost as simple as that. So I would need to know, if it's a mining company, I would need to know for sure that it has exploration and extraction licenses for its key products. I would need to know that it has the ability to use the land where it sits. I would need to know what the environment is like in terms of pollution. What are the costs? What are the penalties? I'd need to know what are the products, what are the price for those products, who are the customers, where do I export, what are the potential risks? And these may seem like commercial questions, but from a lawyer's perspective, what you are trying to do is to ensure that you've given everyone the information they need to make an informed judgment. In terms of technical expertise, the one area which is very specialist is if you're offering to US investors. And a lot of major offerings are extended to US investors, and they're not listed on the SEC in Washington, but they take advantage of an exemption that's available to qualified institutional buyers in the United States, where you can offer to those professional investors, but your offering document has to comply with certain standards that are based on US disclosure standards. And if you're doing that process, there are implications, because an American lawyer will have to be comfortable that you haven't done anything which triggers a requirement to go to the US regulator and get the prospectus approved. And it is market practice that in those types of offerings, a US lawyer will also sign what we call a disclosure letter, 10b5 disclosure letter. And that will say broadly, we as knowledgeable US securities lawyers have done what we would normally do, and nothing has come to our attention that would suggest to us that there's any material inaccuracy or omission in the offering document. And you have to have a US lawyer involved to make those statements. So that one is quite restricted. You would need to be US qualified in order to work on that aspect of the transaction. It is critical, though, if we are involved in a major international offering, all the lawyers, whether they're US or not, need to be broadly aware of the US securities restrictions and what we can and cannot say. So, for example, US securities laws have extraterritorial effect. So if I'm a business in Angola listing on the stock exchange in Egypt, because I'm doing a cross-border listing, I am potentially subject to US securities laws, which seems surprising, but that's the way they work. But as soon as I start offering to US investors, I have to make sure that I'm not doing anything that would trigger a requirement to go and register my prospectus, get it approved by the SEC in Washington. So that is quite a critical part of the process. So, for example, I had a client once many years ago, and we had said what you mustn't do is you mustn't do any promotion of this securities offering in a way that could be seen as marketing it in the US. And we knew he was about to go on a visit to the US. So we spent a lot of time saying, do not mention the IPO. Do not mention the IPO at all. Don't mention it. And I was told that he was in some conference and someone asked him, well, what are your IPO plans? And he said, my lawyers told me not to discuss our IPO, which was a little unfortunate. But that is, to answer your question, there are specialist areas you need to be familiar with, but there's no real restrictions unless you get into US securities offerings.
Thank you so much, Mr. Pearce. I believe that was the last question for today. Well, let's call it a day. Thank you very much, everyone, for joining us today. And thank you, Mr. Pearce, for your valuable time today. I know that usually you do counseling not free of charge, but thank you for doing it for us today.
My pleasure.
And we believe that November session was successful, and you may see it later on our YouTube channel. Okay, good evening, everyone, and have a nice rest of the day. Thank you. Bye-bye.
Thank you very much. Bye.
Thank you, Roy. Bye.
Thank you very much.
Thank you very much.
Bye.